Welcome to the debate. Our focus today is one of the foundational yet continuously contested provisions of the American legal structure, the 10th Amendment. It guarantees that the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. Now, this provision is the primary constitutional recognition of federalism, the necessary division of power between the states and the national government.
And that division, often called dual sovereignty, it's far more complex in practice than that simple text might suggest.
Indeed it is, and that complexity leads us straight to our central question for today. What is the true legal status of the 10th Amendment? Is it primarily, as some argue, a symbolic truism, basically just restating that the federal government has only enumerated powers? Or is it something more, an independent, substantive source of constitutional law that the judiciary actually uses to impose limits on otherwise valid federal power? I'll be arguing for the former view, that the 10th Amendment is fundamentally a truism, intended mainly to reinforce the original design and, importantly, should limit judicial intervention.
Okay, and I'll be taking a different approach. I'm going to argue that the 10th Amendment, particularly when you look at how doctrines like the Anti-Commandeering rule have developed, provides a necessary and judicially enforced structural protection for state sovereignty. So, yeah, the text might sound declaratory, but its function is essential to preserving that balance of power.
Right. So my perspective is really rooted in the history, the Constitution's formation, and the early jurisprudence. The Supreme Court itself has for a long time affirmed this view. If you look at United States versus Darby back in 1941, a major case upholding federal labor standards, the court actually called the 10th Amendment but a truism and essentially a tautology. It confirms the limited nature of federal power, sure, but it was never intended, I think, to be a source of power for the states or, crucially, a way to strike down otherwise legitimate exercises of Congress's Article I powers. To really get why, you have to look back at the drafting of the Bill of Rights. The framers specifically considered and rejected adding the word expressly before delegated. That word was in the Articles of Confederation, and it was seen as a fatal flaw.
Chief Justice Marshall famously argued this in McLachlan versus Maryland in 1819, the National Bank case. He said omitting expressly was critical. It allows Congress broad discretion through the necessary and proper clause to choose appropriate means to carry out its delegated ends. So if Congress has chosen a necessary and proper means to implement an enumerated power, the 10th Amendment, by its own words, expressly disclaims any reservation of that power to the states. The real check, therefore, has to be found within the boundaries of Article I itself, not some external 10th Amendment restriction.
Okay, that's a rigorous argument for textual precision, I'll grant you that. But it seems to focus almost entirely on the source of the power rather than the structure of how that power can be legitimately exercised. Now, I accept that Congress has implied powers, and I agree the 10th Amendment doesn't suddenly create new powers for the states. But it absolutely functions as a vital structural principle. It reserves a core domain of sovereignty to the states and the people, and critically, it acts to protect individual liberty by ensuring, a healthy balance of power. This structural role is, I think, most clearly visible in the Anti-Commandeering doctrine. It was first explicitly adopted in New York v. United States and then perhaps even more forcefully applied in Prince v. United States. Basically, anti-commandeering holds that Congress cannot compel state legislative or executive processes.
So, for instance, in Prince, the court struck down the Brady Act's requirement that local law enforcement had to conduct background checks for the federal government. This role provides really essential structural safeguards. First, it protects liberty. Second, and maybe most importantly for today's governance, it promotes political accountability. It makes sure citizens know who to credit or blame, is it their state officials or Washington, for a particular policy or its failure. If Congress wants something done, it has to act directly and bear the political heat itself. This structural role is, I think, most clearly visible in the Anti-Commandeering doctrine. It was first explicitly adopted in New York via United States and then, perhaps even more forcefully, applied in Prince via United States. Basically, anti-commandeering holds that Congress cannot compel state legislative or executive processes. So, for instance, in Prince, the court struck down the Brady Act's requirement that local law enforcement had to conduct background checks for the federal government. This rule provides really essential structural safeguards.
I see why you think that the anti-commandeering rule is a sort of necessary structural correction, but let me offer a different perspective here. Your reliance on the doctrine seems to suggest that a power can somehow be delegated under Article 1, yet simultaneously reserved under the 10th Amendment. Given the amendment's actual wording, powers not delegated are reserved. That seems like a logical impossibility, doesn't it? If a law is a valid exercise of Congress's enumerated powers, including the necessary and proper means to achieve it, then the 10th Amendment just offers no refuge. The McCulloch decision was pretty clear that the necessary and proper clause is a grant of authority, it's not a restriction. Where I struggle is how this doctrine carves out these exceptions that effectively seem to render the necessary and proper clause kind of useless in certain situations.
Isn't Congress simply choosing what it deems an appropriate means to regulate commerce? I mean, if it can achieve a regulatory end by setting up a whole new federal agency, why can't it achieve the same end by requiring the state government acting in its executive capacity to help out?
Yeah, I'm sorry, but I just don't buy that the necessary and proper clause provides a blank check to basically obliterate the separate sovereign structure of the states. The 10th Amendment, or at least the principle it embodies, ensures that when the federal government acts, it generally acts directly on individuals. That was the foundational design Marshall himself talked about. The anti-commandeering principle enforces this by prohibiting the coercion of the state's own governing apparatus. I really don't think the framers intended the necessary and proper clause to let Congress just demote the states into being, mere administrative subunits, basically forced to carry out federal law under threat of punishment.
But isn't that sometimes the most efficient way?
Maybe efficient for Congress, but it muddies the waters of political responsibility and weakens local government. That clarity of accountability I mentioned earlier is just vital. And look, the political process alone, as we saw in the cases leading up to the New York decision, it actually failed to protect state prerogatives adequately. The court had to step in because, as it said, the Constitution protects state sovereignty, not just for the state governments themselves, but for the protection of individuals. And this brings us back to the legitimacy of the doctrine. It gives the 10th Amendment necessary teeth. State officials, the court said, even if they personally agree with a federal program, cannot consent to the enlargement of the powers of Congress beyond what the Constitution allows. That's a clear structural check. It shows the 10th Amendment is, in practice, more than just a truism. It imposes a non-textual, non-enumerated limit on how delegated federal power can be deployed.
Okay, that's a compelling argument for the need for some kind of judicial intervention, perhaps. But I would frame the source of that limit differently. Let's be honest, the complexity and sometimes inconsistency of the anti-commandeering doctrine suggests to me it's less a principle flowing directly from the 10th Amendment itself, and maybe more of a federalism-informed interpretation of the actual limits of Article 1 powers, especially the Commerce Clause. I mean, if the 10th Amendment really provides such a clear, standalone limit, why is the resulting doctrine so, fact-dependent and frankly hard to apply consistently? Consider the distinctions the court itself draws. This anti-commandeering rule does not apply, apparently, when Congress even-handedly regulates activity in which both states and private actors engage. Right? So that led the court to uphold federal requirements in Reno v.
Condon back in 2000, regulating state DMV databases alongside private database owners. And even more recently in Holland v. Brakian, certain requirements applied broadly to any party in court proceedings, which included state courts. And yet the doctrine is triggered when the feds try to control the state as a regulator or as a sovereign entity, like when they banned state authorization of sports gambling in Murphy v. NCAA in 2018. Why is forcing a state to regulate gun sales commandeering, but regulating how a state manages its own databases, which seems like a pretty core sovereign function, somehow not commandeering? The distinction seems to hinge on this tricky idea of whether the state is acting in a purely governmental capacity versus acting more like an economic participant or, a database owner. This highly technical, judicially drawn line, for me, supports my basic point. The limit is really about the scope of the Commerce Clause power over state actors, informed by federalism, yes, but not dictated by an independent 10th Amendment rule. The complexity, I think, actually erodes its credibility as some self-evident constitutional protection.
Well, I'd argue the complexity is a necessary consequence of, well, the complexity of modern government, not really a sign of the doctrine's incoherence. The crucial distinction you highlight between regulating the state qua state, commanding its unique regulatory powers, versus regulating the state just like any other private entity, that is the important line. The fact that the court sometimes struggles to draw that line perfectly only demonstrates how vital the underlying 10th Amendment principle is. It forces the court to constantly grapple with where legitimate national regulation ends and where unconstitutional coercion of the sovereign state structure begins. And let's talk about the political consequences you brought up. We definitely see today what people often call fair weather federalism. You're right, both conservative and liberal political forces seem to invoke the 10th Amendment or cite Prince pretty instrumentally, basically only when it suits their current policy disagreements with Washington. So, sanctuary cities cite anti-commandeering principles against federal immigration enforcement, just as states with different politics might use the same doctrine to fight federal environmental rules.
Exactly. And that instrumental use is precisely why I view it more as a political talking point or weapon than a stable legal principle. When it's just deployed strategically against whichever party happens to hold power in Washington at the moment, it suggests to me that the most reliable check isn't some vague judicial test about commandeering, but rather the political process itself. Congress simply refusing to pass laws that truly exceed its Article I limits. The political motivation behind its use really undermines the claim that it's providing consistent structural protection.
I'm not sure I'm convinced that the political motives of the actors necessarily diminish the constitutional protection itself. You could argue that the constant strategic conflict between state and federal ambitions is actually a feature, not a bug, right? That's part of the Federalist design. The fact that states like California and Texas, regardless of who's in the White House, routinely challenge what they see as federal overreach, that shows the structural protection is still alive and kicking, even if it's used strategically to push different agendas. Federalism is supposed to give people multiple points of access to challenge government power they disagree with. Without something like the anti-commandeering rules, states might be entirely at the mercy of Washington's whims.
Okay, but let's pivot slightly because we haven't really touched on the elephant in the room when it comes to federal influence over states today. Even if anti-commandeering blocks direct orders, what about Congress's power under the spending clause?
Ah, yes, the power of the purse. This is arguably where the federal government exerts massive influence, often achieving the same policy goals without technically, quote-unquote, commandeering anyone in the Prince sense.
Exactly. Congress can't directly command the state legislature to enact a specific law, maybe, but it can say, we'll give you billions of dollars in highway funds if you set your state drinking age to 21. That's not a direct command, it's a condition on funding.
And this highlights a potential weakness, or at least a major complication, in relying solely on the anti-commandeering rule to preserve meaningful state sovereignty. Congress can essentially buy state compliance through the spending clause, and often this achieves pretty much the same level of federal control over state policy without triggering the Prince alarm bells. So the 10th Amendment shield against direct commands can start to look a little hollow if states feel effectively forced to comply anyway to avoid losing critical federal money.
And this whole issue came to a dramatic head in the big challenge to the Affordable Care Act, NFI v. Sebelius, back in 2012. Remember, the ACA required states to significantly expand their Medicaid programs, a huge new cost for them, or risking all of their existing federal Medicaid funding.
Right, a massive threat.
And the Supreme Court, in a really significant ruling on federalism, actually said Congress had gone too far there. Chief Justice Roberts, writing for the key part of the opinion, argued that threatening to withdraw all that existing Medicaid money, which for many states was, 10% or more of their entire budget, crossed the line from persuasion into unconstitutional coercion.
Precisely. And that decision, importantly, defines a limit on the spending clause power, grounded in similar federalism concerns. Roberts basically said that the distinction between a permissible spending condition
and impermissible commandeering sort of collapses when the state has no choice but to accept the conditions. The state has to retain a genuine option, he argued. Otherwise, the financial pressure becomes coercive, effectively achieving through the back door what direct commandeering prohibits through the front. So this, to me, confirms that the underlying 10th Amendment principle that the feds can't just command the state's apparatus operates structurally, even when the mechanism shifts from direct orders to financial threats.
But, and this is a big but, even that coercion limit is incredibly difficult to define and, frankly, enforce consistently. The court itself acknowledged in NFIB that pretty much all federal spending conditions are coercive to some degree. The threshold they identified in that specific case, threatening such a massive chunk of a state's existing budget, was arguably so high that very few other spending clause conditions are likely to reach it. So while there's now technically a judicial limit on spending power coercion, the practical reality is that most federal funding conditions, even if quite coercive, probably remain perfectly constitutional. This allows Washington to steer state policy much more effectively than if it could only rely on direct regulation of individuals. And this heavy reliance on financial leverage, I think, further supports the view that the old Darby truism is the real foundation.
The most effective limits on federal power are likely found in the political will of Congress not to overspend or overreach, not in these sort of vague, hard-to-apply judicial lines around commandeering or coercion. So ultimately, the core of the matter, as I see it, remains that the 10th Amendment is best understood as reinforcing the basic structure of enumerated powers. That was true from the start. And while, yes, modern courts have tried to give it substantive teeth through doctrines like anti-commandeering and the spending power coercion limit, the resulting complexity, the inconsistency, the strategic deployment we talked about, it all suggests that the most reliable check on federal power still lies in a rigorous interpretation of Congress's Article I grants, just as I believe the framers intended when they deliberately left out that word expressly.
Well, while I appreciate maybe the tidiness of relying solely on enumerated powers, I still maintain that the 10th Amendment's structural role is both complex, yes, but also absolutely necessary. Necessary for accountability, necessary for liberty. The anti-commandeering principle, maybe imperfectly but importantly bolstered by that coercion limit from NFIB, protects the fundamental design of dual sovereignty. It ensures or tries to ensure that the national government can't just completely co-opt state governments to implement federal programs, thereby preserving at least some space for robust state capacity and responsiveness in our very large and diverse republic. That balance is crucial.
We have certainly highlighted the deep, ongoing tension between the potential sweep of the necessary and proper clause and the idea of reserved state authority. And I think the difficulty in clearly defining both direct commandeering and financial coercion shows that this federalism debate is highly dynamic and really far from being settled law.
Absolutely. There's clearly more to explore in the material, particularly around where that line between federal persuasion and unconstitutional compulsion truly lies in modern American governance. It's a critical question.
Thank you for this rigorous discussion.